What if I told you that all debts may have already been paid under US law? What if I told you that there is a little known statute under 12 USC 95A that some researchers claim can be used to challenge and discharge debt? One of those researchers being myself. But banks and creditors will never talk about this. Why is that? In this video, we're going to be breaking down 12 USC 95A, what it actually says, how it connects to debt discharge, and how you can use it to fight back against lenders. Just to tell you a little bit about myself, I've been studying consumer law since 2021. Some of you guys have been studying this for a long time, but I don't know if it's a day and age of information overload, easier access to information, or I just have the mindset to dive deep into this research. But when it comes to consumer law, when it comes to banking regulations, when it comes to debt loopholes, when it comes to understanding consumer law, the federal law, and how to be able to apply it, I don't know what it is, but today I'm going to be exposing what they don't want you to know, okay? And essentially, they don't really truly want you to know how debt works. So if you're brand new, like, comment, and subscribe, okay? If you like, comment, and subscribe, and you tap in with me, I'll continue to tap in with you and drop in more bangers. Also, if you haven't watched any of my previous videos, I'll put them down in a link in the description. Some of the videos that I think would be super essential to watch, from understanding how mortgage debt works, from understanding how rent works, from understanding how to discharge debts and communicate with debt collectors. I'll put those down in the description. May even create a playlist. I'll put that playlist out there too, okay? Also, like the video. I don't know if I already said that. And down below, make sure that when you get to the end, you guys are putting the things that you want to learn that connects with what I talk about, okay? Now, my goal today, man, is to really put you guys on game, you know, because a lot of people look at debt discharge as a fantasy, you dig me? But it's not really a fantasy if Congress put the information out there for you to actually view, you dig me? If I'm able to look these things up, then it's not a fantasy, all right? So when we tap into 12 USC 95A, I hope y'all can see it. Maybe I can zoom in a little bit, okay? Adjust some of these things. Now, it's clear on house.gov. So again, this is not something that is just coming out of the blue, okay? So understand 12 USC 95A, regulation of transactions and foreign exchange of gold and silver, property transfers, vested interests, enforcement, and penalties. Okay, it says text contains those laws in effect on January 2, 2001, and right now we're in 2025. So obviously we are in a position beyond that. Okay, and a lot of these concepts have been originated from as far back as 1933. Okay, this originates from the Trading with the Enemy Act, or the TWEA, of 1917, which was expanded in 1933 under Franklin D. Roosevelt's Executive Order 6102. Okay, so you guys can tap in, you guys can look these things up, but again, this originates from that law that essentially was an expansion from an executive order, and you know, even dates back to 1917, and we're in 2025, so a little over 100 years ago. Essentially, this order allowed the government to seize gold from U.S. citizens and suspend the gold standard. So when you suspend the gold standard, that means that gold is not the standard of money, and they cannot collect debts from you, okay? Also, at the same time, let's just say that gold is the only real money. If the U.S. seized it from us, then what can we use to pay for our debts? You dig me? This statute also declared that all obligations are now paid under public policy since the U.S. switched to a debt-based financial system. Okay, so when we look at what it says during the time of war, the president may, through any agency that he may designate and under such rules and regulations as he may prescribe by means of instructions, license, or otherwise, investigate, regulate, or prohibit any transactions in foreign exchange, okay? Transfers of credit or payments between, by, through, or to any banking institution, and the importing, exporting, hoarding, melting, and earmarking of gold or silver, coin or bullion, currency or securities, and investigate, regulate, direct, compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, exportation, or dealing in, exercising any right, power, or privilege with respect to, or transactions involving any property in which any foreign country or national thereof has any interest. So, long story short, during this time of war, the president may investigate, regulate, or prohibit transactions in foreign exchange, transfers of credit, and the exporting of currency. Okay, so another thing I want to highlight is the fact that under 95A2, any payment, conveyance, transfer, assignment, or delivery of property or interest thereon made to or the account of the United States, or as otherwise directed pursuant to this section of any rule, regulation, instruction, direction issued here under, shall to the extent thereof be a full acquittance and discharge for all purposes of the obligation of the person making the same. And no person shall be held liable in any court for or in respect to anything done or omitted in good faith in connection with the administration of, or in pursuant of, in reliance, this section, or any rule, regulation, instruction, and direction issued here under. Okay, so 12 USC 95A2 essentially says that, boom, obligations are acquitted and discharged. Dig me? And even when we talk about the full faith and credit clause, or if we talk about good faith, which essentially puts even lenders in a position where if there was something disclosed, if it was something disclosed in another state, then it has to be adhered in another state as well. And then the aspect of good faith, meaning a lender must move with honesty. Okay, so if you ask them, hey, is your signature created in credit, then they have to essentially adhere to the good faith principle, and they have to say, you know what, yes, your signature created the money. But if they fail to disclose it, then essentially they are violating the good faith principle. Okay, so we'll talk about that challenge in a second. But the aspect I wanna speak to is essentially the what 12 USC 95A pretty much suggests. Okay, since 1933, the U.S. operates under a fiat currency system. Okay, where money is no longer backed by gold but by credit. You dig me? And if money no longer backed by gold, and you cannot ask for gold, nor on the aspect of gold was confiscated from the public, how can debt be legally enforceable if it's all credit? Dig me? We talked about this in my previous video. We talked about this in the videos prior, that money is literally created out of thin air. When you apply for something, you put in that application, your signature actually gets monetized and turns into a financial asset according to the fact since 1933 when they created this fiat system. Okay, so 12 USC 95A is another law that enforces the fact that debt is already discharged and already prepaid. Dig me? So now the question is, how can I use 12 USC 95A to discharge debt? Now, obviously, again, these are laws that's going to back you up in your challenge. This is not the only way that you're going to discharge debt. You have to understand the full legal process in order to do that, and that's something I discuss in my complete debt guide. Okay. Now, here's the aspect of canceling debt using this law. Okay. So we could argue that since the government declared a national emergency in 1933 and suspended the gold standard, all debts have technically been discharged under public policy. Okay, so if it's been discharged under public policy, now the bank has to essentially prove that they are above that jurisdiction. And if you're in the United States, if you are a U.S. bank, then yes, you are not above this policy. You dig me? This is public policy. All right. Now, This also means that the banks may not actually loan real money, which we discussed, because this is in modern money mechanics, where it says that they instead create credit through ledger entries. Okay, so modern money mechanics affirm this, which is the book of banks, and also at the same time, we have laws put in place that says that your obligations are acquitted or discharged. And then we talk about the full faith and credit and how this is a full credit system, and each state has to treat each law. It can't be, okay, in this state, oh, it only works in that state. No, it doesn't work like that. You dig me? Every state has to honor the public policy. Okay, nobody is above it if we're talking about the banks in the United States. All right. So now it's the other aspect of here are the legal arguments of that. Number one, if the banks don't lend actual money, what consideration do they provide in your loan contract? Consideration meaning, where does the money come from? Okay, so if you guys don't lend actual money, how can you sit there and say that you loaned us money? Okay, you are violating the full faith and credit because you clearly didn't loan us money. It's clear and it's already documented, not only because I'm saying it, but the law says it. The public policy says it. Okay? A book about your fractional reserve system says that. The Federal Reserve Act Section 16 says that. You dig me? So if they are saying these things, then boom, you now ask the question of what is the consideration through their loan contract? How is it even a loan contract if you didn't loan me money? Okay, if it's a loan, then there's an exchange. You feel me? Or as a matter of fact, if it's a contract, then there's an even exchange. If I signed something that you then went and made money on, and I didn't even get no real money out of it, but you typing something in my bank account, yeah, there is no consideration of a real contract, okay? Then the other question is, if the U.S. government declared debt obligations to be paid under public policy, why are we still paying banks, okay? If they discharged it, what is the bank hoping for? They know this already, okay? And then the other question is, does this mean that we can legally challenge the debt enforcement? See, the whole aspect of debt discharge is challenging whether they have the position of enforcement. Yes, we can prove the fact that the debts are discharged, but it's not on the aspect of where you'll tell them your debt is discharged and you just stop paying the debt. You're going to have to pretty much challenge their enforceability, if that's even a word, if they can even enforce that debt in the first place. And you have to provide evidence as to either their misrepresentation, them violating the good faith law. Okay, so if they're doing everything that they're supposed to do, then yeah, they would essentially tell you the truth. They wouldn't give you no BS. You dig me? So then we tap into how to use 12 U.S.C. 95A to challenge debt. So step one, what you want to do is you want to demand proof of loan funding. It's very it's not very simple, but that's the basis of your argument. You want to challenge whether they actually got funded or they even funded you in the first place. And if they did fund you, then you have a right to send them a letter asking them for these things. Hey, how did you fund me? Okay, did you actually use your money, or did you monetize my signature? Did you actually loan me money? You have a right to ask these questions, and the letter or what you would send them is a qualified written request, which is a QWR under the Truth in Lending Act. Okay, you can look up this PDF online, or you can grab the complete debt guide. I will have that template in the complete debt guide. Okay. Number two, you want to request proof that the lender actually loaned you money rather than creating credit from your signature. You dig me? You have a right to ask these questions, and you can simply just ask them these questions. Sometimes you don't even have to think, oh, I gotta be so legal and things in that nature. No, you just need to ask them the question, and they have to, in good faith, perform and answer your question honestly, truthfully, and in good faith. And if they don't do that, they'll be in violation of the Uniform Commercial Code. It's that simple. Then we go to the aspect of using UCC 3-305, which is the holder in due course 3-305. You know what I mean? Where you are essentially protected in the aspect of boom, that you as a borrower have a right to challenge a creditor's right to enforce a debt, okay? And if the lender cannot prove that they are the holder in due course, they may not be able to collect. How they will prove that they're the holder in due course is providing an original note with your wet ink signature. Your wet ink signature, not a photocopy. Again, I will keep repeating these things so that you guys can fully be understood, because what will happen is I'll tell you guys these things and then we're still stuck on, a 1099 and this, that, and the third. But the argument and the challenge that I'm bringing to you is not to where it's a hope. It's where you're asking them these questions and you are now playing offensively. You are now forcing them to provide proof, not you having to continue to provide proof to them, because there's no proof that you need to provide to them because they know this already. You just have to ask them the right questions. And when they don't answer these questions, they are in violation under the Truth in Lending Act, under the Uniform Commercial Code. You dig me? So yes, you can send a coupon. You can send, write your own promissory note. You can do a 1099 and things of that nature. But yes, all of this is important, but it's not that needed if you understand how to communicate with them, understand what questions to ask them, understand that when they don't answer these questions properly, you can hold them accountable to it, my baby. So, boom, let's dive into how to essentially file a dispute with 12 U.S.C. 95A, okay? You want to send a legal debt validation letter, okay? And all this can be in one letter. We're asking them if they're the holder in due course, asking them to demanding proof, okay? But you want to reference 12 U.S.C. 95A, okay? Reference, hey, under 12 U.S.C. 95A2, it says that all debts are discharged and acquitted, okay? So essentially, I want you to prove that the debt is not already paid under public policy. And if you give me some BS saying, oh, you know, that doesn't apply to us, you are not moving in good faith. You're actually lying to me. And you can tell me everything you want, but go ahead and put it in writing so that when we get to court, I'm going to challenge everything that you just said. Okay? And the court is going to have to honor that under the good faith. The court cannot lie to you either. Everything at the court is going to be on record. So you can BS me all you want, but it's not really going to work if I know the truth. Okay? They cannot enforce a judgment if they cannot prove or demand, or when you ask them for the proof and they didn't provide it, they cannot enforce the judgment. Okay? It's not legal advice. Do your due diligence. Request that the lender shows you how the debt was created in lawful money, not just ledger entries. So you want to ask them these questions, these specific questions. Hey, how did you create the money? Boom. If you're saying that you loaned me money, how did you get the money? Oh, you got your money through fractional reserve banking? Oh, so that means you was already paid. Forget that you're saying that everything is discharged. Now we're talking about you already being paid for my promissory notes from my signature. I gave you the right to create credit. When you look at the definition of a creditor under the Truth in Lending Act, 15 U.S.C. 1601, you dig me? Maybe a 1602, definitions and rules of constructions. It says credit means the right granted by a creditor to a debtor to defer payment of debt or to incur debt and defers payment. The right granted. You feel me? So I granted you the right to create credit. Okay? Because guess what? A creditor refers to only a person. Dig me? So again, you go ask, okay, well, what is the point of you telling me this? Well, let's look at the definition of person. It seems a person means a natural person or an organization. Okay? And then you will say, okay, well, all right, organization, natural person, okay, bet. Organization means a corporation, government, governmental subdivision, agency, trust, estate, partnership, cooperative, or association. So, organization is capital one. Organization is that loan company. Organization is that mortgage company. But let me ask you this. Can an organization, does it say under the definition of organization that they can be a natural person? A natural person is somebody who has a body, living and breathing. And can't nobody, you feel me, have more power than a living, breathing person. You feel me? Look, if they don't have this, they cannot create credit. You dig me? Like, come on now. I ain't have to show the guns on y'all, but that's literally it right there. You dig me? And this is under the Truth in Lending Act. Congress put this together, 12 U.S.C. 1602. You feel me? You can go look at these definitions all you want. But what I'm telling you is that they are unable to prove their legal stance of even creating credit in the first place. And if you tell me that you loaned me money, you are literally lying. So it's not that you'll sit there and fight them, and when they say, oh, we did loan you money, or these laws don't apply to us, okay, bet, prove it in court. Don't just go based off of what they say. Tell them to prove it in court, my baby. So then we go to step 4. And if they want to make up this bullshit lie, then you want to file a complaint against the lender, okay? So if the lender cannot provide proof of funding, you want to file a complaint with the CFPB, the FTC, and your state attorney general. And because if the government declared debt is paid in 1933 and the banks don't lend real money, how can they legally enforce debt? So this is when you tap into the CFPB. The CFPB, you go... I just tried to pull up the CFPB website, but it's not allowing me to reach it. But essentially, when you bring up the CFPB, I'll show you guys. I'll try to access it. Maybe you guys be able to access it. But when you go to the CFPB, you essentially go and you'll submit a complaint, and you'll put fraudulent lending practice or debt, anything that deals with debt collection and things of that nature, and you want to follow that form based off of these things. And when you go through the complaint process, you want to quote these laws. You want to quote what you have done. You want to include your evidence. You can't go to the CFPB first. You have to do the actual administrative process, the actual legal process, before you decide to go to the CFPB, the FTC, or the state attorney general, or it will not work. Okay? They're going to just push you off. They're going to say, hey, you can't do this, or they're just going to be looking for that evidence. And if you can't provide that evidence, then they're going to basically make it seem like nothing could be done. Also, even after you do the CFPB and all of these aspects, you have to be willing to sue the debt collector. You have to be willing to sue the bank. If you're not willing to sue the bank or take them to court and have them prove what it is that they're trying to say that they can or can't do, or did not do, the only person that you can truly have this be enforced is if you take them to court. And when you think of the aspect of taking them to court, small claims is 10,000 or more. 10,000 or less. So if you spend less than 10 grand, or if you want them to, or if you're suing them for less than 10 grand, some states are different, 15 grand in some states, 20 grand in some states, then you can go ahead and represent yourself, okay? Still consult a legal professional and an attorney on the consumer law protection side. I'm actually starting to build my connections so that we can start to get more consumer protection lawyers out there that are even tap into pro bono, but we'll talk about that at a later date. Then we tap into if it's anything above 10 grand, okay? This is when you want to take it to a federal level, okay? But if we're talking about a debt that's discharging, you're just challenging whether the debt is discharging, you want to challenge them on their violations, then you shouldn't really have to go over 10 grand or more, okay? Because if you send these letters over a couple of months and the violations of the Fair Debt Collection Practices Act is, let's just say, 1,000 or so, then, if you sent over 10 letters, then, and they gave you insufficient responses, then, that's 10 grand and so. But if you catch them for other violations where they misrepresent, lie, and things of that nature, under the Truth in Lending Act, it says they will be under criminal liability. So if you bring these things up in court, you challenge these aspects of them, they can be in a position where they are criminally liable for violating your rights, okay? And the thing is, when it comes to the court system, or when it comes to any legal battle, if you're able to prove to them that you'll potentially win in court, they will settle, okay? Whether it's they're going to stop bothering you and stop pretending like you owe them money, or they're going to straight challenge, or they're going to take it to court with you, okay? And the only time they would do it is if your negotiation skills are not that good, okay? But when you get there, if you have your documents and your evidence and you are able to show that you're going to win, they will settle, okay? Again, no promises. Again, you have to be well versed on these laws. You have to go take a look at these laws yourself. You have to be willing to do your due diligence. Tap in down below with the Complete Debt Guide. The Complete Debt Guide is only $47 and essentially teaches you the entire administrative process and how to communicate It includes all the templates and things of that nature that I talk about in my YouTube videos. And my YouTube videos really bring clarity to what I teach, okay? Now that you guys kind of know the hidden truth behind 12 USC 95A, this is things that nobody is talking about, and essentially how you can use it to challenge debt. Again, this is just one law, but there's so many laws that you can put in one debt validation letter that they have to prove, okay? So if you guys understand that, thank you for watching the video. Make sure you guys are like, commenting, and subscribing. Down below, go ahead and take a look at the complete debt guide. It's only 47 bucks. Number 2, I have a one-on-one mentorship. Go ahead and sit down below. It's more credit and financial literacy and financial freedom focused. Okay, it's not debt focused. It's focused on building your finances so that you can be able to secure financial freedom. So if it's anything in regards to debt, go ahead and check out the complete debt guide. Continue to watch the YouTube videos and take action on your own. But if you're looking to build your credit, fix your credit, even for the people that do the debt discharge and things of that nature and their credit is shot, tap in my one-on-one mentorship, work with me one-on-one. We're going to build your credit. We're going to work with you to build your credit. And if we fix your credit, you're going to be able to get 100K plus in funding. Okay. Then if we're talking about, hey, look, I want to be able to, fix my own. I mean, I can't put these letters together, or, maybe I don't want to read these things, or I'm in a situation right now where I don't even have the time to learn. Boom, down below, I have Solo Suit. Solo Suit will essentially help you against debt lawsuits, where you can pay up front and they'll pretty much generate the letters for you. And pretty much at any point in the argument, they will be able to help you. Okay, tap in with Solo Suit. And also at the same time, if you're brand new, check out my Instagram page at biz.nick. Biz.nick. It's pretty simple. And check me out. Shoot me a DM if you have any questions about my YouTube video, want to learn more about my products and services. But other than that, man, what do you think about 12 USC 95A? Okay, do you believe debt has already been paid under public policy? Drop it down below in the comment section. I want to hear your thoughts. And don't forget to like, subscribe, and turn on post notifications, because I do post daily, okay, at least 5 days a week. We'll probably bring it up to more videos, but I think that right now we're pretty much, this is giving me time to really put my videos together and do the research and due diligence. And this is something that I pretty much am on a daily basis doing. So turn on the post notifications, and yeah, so you can get the notification of the next video for tomorrow. All right. But other than that, thank you guys once again, and I'll see you in the next one.